This is The High Road with author and registered psychotherapist, Dr. Marlene Bizum. Dr. Marlene speaks to the heart of people who need to be lifted up and get out of the muck and mire that often accompanies major life changes, such as divorce or separation. Dr. Marlene will aspire to help parents of divorce to love their children more than they hate their ex, and to learn to take the high road. So please welcome the host of The High Road, Dr. Marlene.
Good morning, or good afternoon, or good evening. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We've got a great show. Of course, I say that every week because every week we do have a great show. But I'm especially excited today because I feel like I'm going to learn a lot from you, George. We're going to talk about a hot topic, and that is decision making. And I have to tell you, I talked to a client just 2 days ago about decision making. He was asking me a bunch of questions about how it works, and I've got some questions for you. I will be able to answer his questions. And you had no idea that my client was asking me questions about this when you suggested talking about this topic. But it's a great topic. And not to put you on the spot, but I am going to let you just kind of explain to me and everyone else the difference between soul and joint. And I'll ask questions along the way, but take it away.
Well, good morning, Dr. Marlene. At least in our time zone, it's great to be with you again. I think it is an important topic, and that is the distinction between joint or soul decision making. In Colorado, we have gotten rid of the term custody, but a lot of people would understand custody meant the authority to make decisions with regard to a child. And of course, the court has choices between joint decision making or joint legal custody and sole decision making or sole legal custody. And the areas that are talked about in terms of those decisions are religion, if any, uh, educational decisions, and medical decisions. And so the person who receives the authority to make those decisions has what we call sole decision making, or we used to be called sole legal custody. Now, I've seen many judges say in a ruling, you're going to share decision making. And in the tension of the courtroom, the parties often are shocked by that. They say, how am I going to get along with my ex that I can't stand to make parental decisions? And I think that's where you come in, Dr. Marlene, with the importance of having a parent coordinator or decision maker, because the parties, they don't know how to communicate with each other without the anger and hatred. And yet here the judge has put them in the position where they have to make those decisions. And so
Right.
the parties really they don't have definition about how to do that, how to communicate without the anger, and prioritize what's best for the children. So I would give it back to you to talk about the importance of having a parent coordinator or decision maker on the case to help parties learn how to communicate jointly when they often can't stand each other, and the thought of communicating with each other is not pleasant for them.
Yes, it's a challenge for sure. And I just said this last night. This is one of the topics, the many topics we cover in the co-parenting classes that I teach for the court. And I taught the level 1 class last night. So the basic class. And we were talking about this. In fact, I spent 20 minutes on this topic. But um, there is one other area of decision making. You mentioned the main ones, of course, and you're the attorney, so you can tell me if I'm wrong. But there also is decision making about extracurricular activities in addition to education, medical, and religion. And that's the one I have the most trouble with the parents I work with. And I'll come back to that, okay? But something that I was talking about last night with the parents who were there is because they are at this time so angry with each other and maybe hurt, bitter, resentful, have feelings of betrayal, whatever it is they're feeling, they do not hear anything the other parent has to say in a positive and rational and meaningful, constructive way. They right away hear, you're trying to control me. You're trying to tell me what I'm going to do, that kind of thing. So, actually, what I do as a parenting coordinator, and there was a guy last night who recognized we are going to need a parenting coordinator decision maker. How do I get you or someone on board? But I tell people one of the greatest and simplest tasks of a PCDM is simply approaching the other parent with the question or proposal that one parent has. But when they hear it from me, they receive it completely differently than when they hear it from the other parent. And even you, as an attorney, they're not going to hear it well from the other party's attorney. And so the other parent and their attorney really are not in a neutral place to recommend something or ask a question or make a suggestion. And as a PCDM, we can do that. And like I said, parents will answer completely differently if it's me asking than if it's the other parent. We even joked last night that I have had parents, and this is true, it's funny, but it's true. I have had parents who have said and actually done this, that they're going to propose the exact opposite of what they want because they know that other parent is going to take the other position. And so if I say I want this, they'll agree to the opposite, and the opposite is really what I want. So I don't know how much of that you see in your role as the person representing one of the parties, but I'm sure you hear about it.
I hear about it, and of course, my ability to assist the client in that regard is fairly limited. I can suggest ways to communicate. I can counsel that it's time to act in the best interest of the children as opposed to the hatred of the ex. But I really don't have the tools to deal with the communication issue between the parties. I'm not given any role in that regard. Once the gavel
Right.
falls, if you will, unless there's a post-decree action, my role with the parties is pretty much terminated, and as well for my opposing counsel.
Yes. And I think what's a really important point to make here for people to hear is at the time you are done, the emotions are still pretty high and pretty raw. And that 2 years that we get to work with people after they have final orders, that is really a beautiful time to work with people because as each month and even week goes by, that anger and frustration and everything they're feeling lessens each week, each month. And often by the time we're 6 months into the 2 years, I am able to say to parents, I'm here if you need me. I'll be here for another year and a half if you need anything. But if you don't need me, you don't need to bother contacting me. Everything seems to be going well. And it will take about 6 months, maybe
Well, and
3 to 6, but yeah, go ahead.
I think one of the concerns that I've encountered before is a parent who has sole decision making, really pressing that issue too far. And an example of that is I represented a client who did not have any decision making authority, with regard to the children. Mom had sole decision making or sole legal custody, and dad wanted to take daughter to church with him. And mom was all kinds of upset about that and wanted to press her position and say, I have the right to make that decision. Of course, we have a Court of Appeals decision that says a parent can take a child to church with them unless the other parent can prove actual harm. So
Mhm.
we actually ended up in a hearing. We had a mental health professional who did an evaluation on the case. And of course, my client ended up having the ability to take his daughter to church with him. But
Yeah.
that's an example of creating kind of a monster or dictator by assigning that sole decision making. And
Mhm.
so small things like that, whether or not a child sees a particular movie with a parent, even though they typically agree will follow the rating schedule. Uh, Little decisions like that are still able to be made and should be allowed to be made, if you
Yeah.
will, by the parent who does not have a role in the formal sense of those topics that we identified.
Right. And what we're really talking about here are day to day decisions. And I explained this last night too, because a lot of parents don't realize that decision making is for major decisions. It's not day to day decisions. And so, you've probably heard me say before, I get parents who call me, they complain because the other parent has kept the child home because from school because they're sick and they have or have not taken them to the doctor or minor emergency or whatever. And they're saying, we have joint decision making, and he or she has not discussed this with me at all. And I have to explain to them that is a day to day decision. That's not a major decision. And so, you get people who carry it to the extreme that every single decision that is made, you have to consult with one another. If that was true, you'd have to live together again. You'd have to be You'd have to be in the home to decide what they're going to eat, what they're going to wear. Those are day-to-day decisions, for sure.
Yeah, I think that's important. And of course,
Yeah.
there's no manual that people receive once the
No.
judge puts that order in place. So they really need to learn a new skill set to communicate without the anger. And that's, I think, a critical role post decree for a mental health professional.
Yes, absolutely. Absolutely. And often they just can't do it for a while. Some people never. I hate to see that ever happen. And we have those few rare cases that they just never are able to work together. Most of the time, a little work will bring them around, but you've got to work with them because, like you said, they don't know this stuff. And the reason this discussion took 20 minutes last night is a couple of the parents kept asking questions because they were curious how it works. As I mentioned a little bit ago, the extracurricular activities are where we seem to have the most conflict. Um, the thing that parents try to do that you can't do is enroll the child in something, call the other parent, tell them, I enrolled Bobby in baseball. You have to take him to the practices and games that fall on your time, and you have to pay half of the fees and his equipment and all that. Well, if that parent didn't agree, he or she didn't agree, no, they don't. No, they don't. They don't have to take them. They don't have to pay unless it's in their order. It might be in their order that they have to share the costs of any extracurricular activities. But it also usually says that the parents agree on. And those are the key words. They've got to agree on them. But I will frequently, this is not unusual, get one parent or the other who just enrolls them, registers them, and then tells the other parent, well, he's all signed up or she's all signed up for football or for dance class or gymnastics or whatever. and you've got to take them on your time and you got to pay half. And like I said, that is not the way it works.
No, that's not the way it works. And I'm speculating here, but I believe that the parents are often somewhere in the grieving cycle, and we're asking them to
They are.
take on this new skill set at the same time. So you kind of have a swamp of emotions and things going on there, which is why I think the mental health professional's role is critical.
Yes, it is. And you're right. They are grieving. And we will talk about that when we come back because I've got a really important point to make. And I'm glad you brought that up about grief because that definitely comes into play here. And a lot of parents don't realize that that's what they're feeling. But we'll talk about that when we come back. Let's take a quick break. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We'll be right back.
What if there were a super tiny device that could diagnose the brain and is smaller than a single human hair? What if you could see inside the brain to help an epilepsy patient during surgery or to help the fight against Parkinson's disease? Dr. Patricia Broderick is proud to announce the Broderick Probe, a biomedical and electronic breakthrough. Imagine a probe to help with the understanding and potential cure of brain-related diseases. To learn more, listen live to the Easy Sense radio show with host Dr. Broderick. And to help support the Broderick Foundation, please go to EasySense.com and learn how, with your help, we can fight these horrific brain disorders. That's EasySense.com to learn more and help support the Broderick Foundation. Author, radio show host, and coach John M. Hawkins reveals strategies to help gain perspective, build confidence, find clarity, achieve goals. John M. Hawkins' new book, Coached to Greatness: Unlock Your Full Potential with Limitless Growth, published by iUniverse. Hawkins reveals strategies to help readers accomplish more. He believes the book can coach them to greatness. Hawkins says that the best athletes get to the top of their sport with the help of coaches, mentors, and others. He shares guidance that helps readers reflect on what motivates them, rediscover and assess their core values, philosophies, and competencies, find settings that allow them to be the most productive, and track their progress towards accomplishing goals.
Welcome back. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. Before we went to break, we were talking about grief and that people going through divorce are going through a grieving process. And they are. And I have to tell you too, George, I'm impressed that you recognize that and, can identify that as what they're experiencing. But it's true. It is what they're experiencing. And part of the grieving process, one of the steps in the grieving process is anger. And so, the fact that people are angry right now because they are hurting so badly, and they might want out of the marriage too, but it still hurts because now you don't have as much time with your children. Your whole world is turned upside down. Somebody has to move to a new home. It's just everything, it affects every aspect of your life, even grocery shopping, things like that. Um, Often parents do that together, or one parent handles that. And now the parent that wasn't handling it will have to handle it. Same with upkeep of a home and a yard and stuff. You might have one parent who always does that. Now the other's going to have to do it too. So there's a lot of reason to be angry and hurt and all those things that people are feeling. But it does jade our perspective, and it jades our ability to co-parent.
Well, I think that's especially true. What I have seen, and it really is not relevant in a legal sense, but in cases of infidelity, because the party feels like I can't trust you in the most basic uh, uh, agreement or implied agreement between the two of us. How can I ever trust you to co-parent? And
Yeah.
so that's a real tough nut to crack. But we all have our hands full in that sense. Colorado is a no fault divorce state, so we don't get into who was unfaithful or any of that. We simply allege that the marriage is irretrievably broken. By definition, under Colorado law, when one party claims that, then it is in fact broken. No further evidence or proof is required in that regard.
Yes. Yes. Well, and another aspect of decision making, especially when one has soul, that I don't think that person who's awarded soul thinks about is typically, and correct me if I'm wrong, this is your area, but typically the order will say you must consult with the other parent. And boy, the parent with soul sure does miss that. And they don't realize that they still have to consult with them. They have to take into consideration what the other parent feels about that decision before it's made. And I have parents who I can see they're just going through the motions. They contact the parent, what do you think? And then before they even get the response, they're making the decision. And so it's very disingenuous often, that they will ask them, but they aren't really interested in hearing their answer. Any thoughts about that? And am I correct? Don't they usually have a statement in there that they must hear from the other parent, get their opinion, or consult with them, however they word that?
And they often do, and it will sometimes specify certain areas where that consultation is required, such as sports, extracurricular activities, things like that. Um, Medical, not so much. I mean, if there's a major surgical decision or something, that goes to the parent with decision-making authority in that regard. And the court can divvy those up. The court can
Mm-hmm.
assign authority for certain areas like medical decisions to one parent. Maybe you have a parent who is involved in the medical field in terms of profession. They might be assigned medical decision making while the parties share the other areas of decision making. So the court has latitude there to construct and try to shape an order that is practical and realistically going to work for the parties.
Yes, yes. And something else I often do, and I think it's helpful. I don't know if my parents do that I work with, but I will write an email for them and send it to them, or a message that they're going to put on one of the apps. Because we typically have talking parents, our family wizard, civil communicator. There's a bunch of them out there. But they communicate through these apps. And I will often tell a parent, if you don't think you know what to say, or I'm telling you, you don't know what to say, you don't know how to say this appropriately, I will send it to them in an email or even a text message if it's brief, and just show them, kind of model this behavior. But to your point that you mentioned early on this hour, parents aren't taught how to do this. And a lot of this is nothing but simple, basic education on how to co parent.
No, I think that's true, and it would almost be helpful if parents were given some sort of a template that they could
Hmm.
look at or rely upon in basic communications. It wouldn't be serviceable for every decision, but for basic day-to-day communications, that might be helpful for them.
Hmm. Yes. And I tell them too, you can tell me what you think of this. You might say that's a horrible idea, but I think it works. I tell them to write as though they know the judge is going to see it. Now,
I think
chances are, yeah, go ahead. Go ahead.
no, I think it is excellent advice because in this day and age, use of email quite a bit, the judge very well may see it. And
Right.
so before they push that send button, it behooves them to think of that the judge is going to read it as well. So I think that's excellent advice.
Okay, good, good. Well, one of the reasons, not the reason, and not even the top reason that we use these apps, but one of the benefits is you can bring them into court and they're unalterable. You can alter texts and emails and things like that, but you can't alter the messages left on these apps. And so that's why the court likes them, one of the reasons. And so if a parent just always writes as though the judge is going to view that, then I think it helps keep them in check because they don't want a judge or someone else to hear what they might otherwise say to their ex partner.
No, that I mean, they don't want to be seen as acting out through
Right,
that language, and
right.
that's exactly how they would. So they're aware. I mean, people have an awareness, but that impulsivity that's driven by anger and frustration. Uh, I mean, I kind of understand it, but we still have to curtail it and get the focus on the children.
Right, right. Well, and to that point, if we focus on the children and not on each other, we'll be okay. We'll be okay. I told them that last night too. And I tell a lot of my parents that I work with that if you focus on the children, don't focus on the other parent, we're going to be fine. And they find if they're able to do that, they're right, we're fine. It's just often they aren't able to do that. They just can't help themselves. And they have to make some kind of snarky comment at the end of their message to the other parent. And it's like, why on earth would you say that? And why would you say it in an app that could be brought into court?
Sure. Yeah, and that creates somewhat of a check and balance, I think, on people when they know that they know they could be reviewing their statement or trying to defend their statement to the judge.
Mhm.
It does act as somewhat of a check and balance on parents going off on each other as opposed to staying focused on the children.
Yes, yes. And you know what I said earlier about 6 months in, parents are often good. And you know what we talk about? I did grief work before I did divorce work. I know you know that, but I don't know that the audience knows that. But that was my primary area of practice was grief before I started 29 years ago doing divorce work. And that's consistent with what we tell people about the grieving process. You're not always all the way through the grieving process because it doesn't work like that. It's not fluid and unilateral, or unidirectional, however you want to put that. But it does take about 6 months, I think, on the average, for people to just be functional again, depending on who it was they lost. But if it's a mate, I mean, it's going to take at least that. Well, it makes sense that 6 months into working together in this manner, the parents are pretty much good to go. Now, I am glad that the court allows us to work with people for 2 years because you have a lot of people who not only hold grudges and have a vendetta, but you have the other parent who continues to dig at them, and try to provoke them. And so then nobody is going successfully through the process.
No, if it's bad enough, then the client comes back to me and says, I want to file a post-decree motion, or they
Mhm.
may not express it that way, but I want to go back to court and have the judge review X, Y, Z. And uh, that's too bad because I have yet to see people litigate their way to a healthy post-divorce relationship.
That's correct. That is correct. And you know what I tell people? Um, this judge is going to hear 2, maybe 3 hours of your family's life. And if you think that's sufficient for them to be able to make the best decision for your children, fine, let's let the judge decide. But if we can figure it out, let's do it amicably. And they still need you as the attorney, me as a mental health professional, but we're not litigating. And judges, I think you said this earlier, they're happy to have you come in with an agreement.
They really are. They review the agreement. Of course, there are certain
Mhm.
things that they might not allow, or once in a while that happens. But typically, the judge is happy to review the agreement. If he or she doesn't find anything untoward in that agreement, they're happy to adopt it. They'll even express there may be a more of a ceremonial type hearing where the judge enters the order and so forth, but there's no real litigation going on. And I've heard many judges compliment the parties
Yes.
for having reached an agreement, and wishing them the best, and being much more pleasant in his or her demeanor than they're capable of being when they're provoked.
Yes, yes. And I've seen the same. I have seen the exact same. The judges will commend them, and yeah, their whole demeanor changes when you're going to litigate and when you reach an agreement. And really, that's the way it should be. And I know we have a requirement here in Colorado that parents have to go to mediation. And I get that. I mean, I think that's a step in the right direction, but again, 1 or 2 hours with a mediator often doesn't cut it.
No, and unfortunately for not for better or for worse, but for worse, a lot of parties see that as something where they need to check the box. This is something that a hoop that the court orders me to jump through. I'll do that, but I'm not changing my position on what I want. And so it's really a perfunctory function. The parties go to the mediation, and it's really not productive. I think the most productive mediations I've seen are those where the parties agree that that's a way they want to resolve their disputes,
Mhm.
and they retain a mediator privately. They're both committed to the process. Those are the most successful mediations, I think.
Yes, I would agree. And I also agree 100% with what you said about a lot of people are just checking the box. They know that they have to go, and so let's go, let's get this over with. They will even tell me, and I'm sure they tell you ahead of time, this is going nowhere. They've made up their minds that it isn't going to go anywhere. They're not going to reach an agreement. Well, if you go in with that attitude, you're not going to reach an agreement.
Yeah, there's no question about it. Either party can certainly blow up the process.
Yes. Yes. That's a good way of putting it because they really can. And we even have a thing, I know you know about this, I don't know if the audience knows about it, called collaborative law, where they try to work together. Each party has their own attorney, they have a mental health professional, they have a financial expert, and we try to I'm part of that group, I guess you'd say. Um, but it's underused. It is so underused.
Oh, I think the collaborative law process, I was early on one of the group of lawyers that tried to bring collaborative law process to
Mhm.
the Colorado Springs area. And our Supreme Court at that
Mhm.
time said, no, you can't do that. It's unethical because each party has the ability to end the attorney-client relationship with the other party by ending the collaborative law process. But it was a great step, and if they're moving toward allowing that, I think it's a great step toward humanizing the divorce process. The collaborative
Yeah.
law cases that I was involved in all ended successfully.
Hmm.
Parties reached an agreement. The attorneys were really exemplary in terms of not being adversarial, making constructive suggestions and observations. And in the collaborative law process, both attorneys can make proposals or suggestions, and so it doesn't have to be, well, you're my attorney, you're my mouthpiece. No, it doesn't work that way. Uh,
Right. Right.
Both attorneys are trying to move the process toward a healthy, constructive solution, and oftentimes they'll use neutral experts, a neutral or mutually retained financial expert or mental health professional to help the process.
Yes. Yes. And I actually want to talk more about this and that opinion that came down a few years back when we come back. But it's time to take another quick break. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. We'll be right back.
Did you know that your beliefs create your entire reality, but it's the subconscious beliefs that do most of the creating? Belief shifter and life coach Shiraz can help you identify those limiting beliefs and eliminate them, often in a single session.
Like it was almost instant, like I had relief right away.
Creating better health, relationships, careers, and finances. Let Shiraz help you step out of safety and into awareness.
Definitely something's happening. It's like a flow inside. You know, it feels good.
Whether in person or online, Shiraz provides personal coaching, belief shifting. Visit Shiraz at energeticmagic.com or call 416-529-7429. Energetic Magic. Find your greater happiness. Be well. Be aware. Be magical.
Are you struggling to care for elderly parents or a spouse? Do you wonder if being a caregiver is making you sick? Are you worried about taking time off work to care for elderly parents and balance work, life, and caregiving? Has caregiving become exhausting and emotionally draining? Are you an aging adult who wants to remain independent, but you're not sure how? I'm Pamela D. Wilson. Join me for the Caring Generation radio show for caregivers and aging adults, Wednesday evenings, 6 Pacific, 7 Mountain, 8 Central, and 9 Eastern, where I answer these questions and share tips for managing stress, family relationships, health, well-being, and more. Podcasts and transcripts of The Caring Generation are on my website, PamelaDWilson.com, plus my caregiving library, online caregiver support programs, and programs for corporations interested in supporting working caregivers. Help, hope, and support for caregivers is here on The Caring Generation and PamelaDWilson.com.
Welcome back. This is Dr. Marlene and George, and you're watching The High Road on the Dr. Marlene YouTube channel. Before we went to break, we were talking about an opinion in Colorado, and this has been a number of years back now, that came down that said, the way I understood it, I think you described it better, George, but basically saying collaborative is contrary to the role of an attorney or something to that effect, correct?
Well, as I understand the opinion, the court, in the collaborative process, the parties agree that if the process ends unsuccessfully, they both have to retain new attorneys.
Yes.
And either party had the ability to terminate the process. So our Supreme Court interpreted that to mean that each party had the ability to destroy or terminate the attorney-client relationship with the other party and their attorney. And so on that basis, they found that it was not within our ethics parameters
Right.
to have each party have the ability to terminate the attorney-client relationship with the other party, basically. But
Gotcha.
before
You
that,
explained that a lot better than me. I don't know all the ins and outs of that, but yeah, go ahead. Before
well,
that.
Before that opinion came down, I was able to participate in several collaborative law cases,
Hmm.
and it was a very positive experience. And so, to the extent that it's permissible by law and for the attorneys, anybody who has the opportunity to try the collaborative law model, I would certainly encourage it.
Yes, yes. And I second that because, back when that opinion came down, it kind of put a damper on collaborative for a while. And then slowly it has worked its way back into, people utilizing the process again. And I agree. There was only a couple of cases that I was involved in before that happened, but I agree they were very positive experiences. And it's a great way for people to not have someone who hears 2 hours of their lives make major decisions that they have to live with.
Very much so. The parties that were involved in the collaborative cases felt, I believe, much more in control of their own lives. They were able to see the attorneys not as the enemy. They were able to see the attorneys bring their experience and knowledge to the table in a
Mhm.
constructive fashion, and it was not it was a non-adversarial process,
Yeah,
and that really says it all for me.
yes, yes. And the attorneys facilitated the agreement instead of representing their client to get what their client wanted.
Right, and I think in the collaborative law model, it was a lot easier to keep the parties focused on the children.
Yes, yes, I would definitely agree. Yes. And I am guessing, going back to our topic, main topic today of decision making, I am guessing more often than not, by a what I'm going to say a wide margin, when parents are able to work out an agreement, it probably does involve joint decision making. Would you
I
think
think
that's, yeah?
Yeah, I think it probably will have some kind of joint decision-making provision. There may be some provision for conflict resolution, such as a parent coordinator decision maker.
Mhm.
Um, but typically it is going to involve some sort of joint authority with regard to the children. And I think parents feel uh, entitled has a bad connotation, but I mean, I think they feel entitled to have a relationship with their children that includes some sense of authority, that they haven't
Mhm.
lost that. Because if they go to court, they're going to lose things. They're going to walk out of that hearing
Mhm.
having lost a number of points that were important to them. So they're dealing with changing roles. We may have the homemaker now employed. We may have the breadwinner doing homemaker chores. Um, we have the grieving process going on. So there's a lot going on with people
Yeah.
to try
Yeah.
to, and so if we can de-escalate that at all, I think it's very helpful. And we can't always do it. We have just the opposite that tends to happen with litigation, contempt citations, things of that nature.
Mhm.
I have yet to, I've seen contempt citations bring people's behavior into conformity with what the particular issue was, the particular violation of the court order. But from that day on, they are always looking for a way to act out against that parent who caused them to face the contempt remedies.
Yes. And it almost becomes a tit for tat, like, well, she held me in contempt for this, and now she's doing that. And so I'm going to file contempt and let her see how it feels. It's almost tit for tat.
It really is. And so it's critical that we have structure in place that keeps the parties from escalating that anger to going into a contempt citation mode or something like that. And I think the best chance for that, not always successful, understandably, but is to have that parent coordinator decision maker in place for parties who have, especially for parties who have shared decision making.
Yes. Yes. And to that point, to your point of it's a process of loss, whether they reach an agreement or not, there's a lot of loss here. And a lot of times parents will say to me when we talk about being a PCDM, because it has the decision maker component, they will often say to me, well, I don't want to lose my decision making. And then I have to explain to them, you're not. You are both still the decision makers. I only step in when you can't agree. And even then, that's the last resort. I am going to work really hard to get people to agree, and I'll step in as a last resort. But boy, they really perceive that if they allow someone to be appointed as PCDM, we're just going to take over. And I assure you, I have no desire to take over. I don't work that way as a PCDM. And I venture to say most of my colleagues who do this kind of work feel the same way. We want to enable and facilitate parents being able to make decisions, but in a healthy and constructive manner.
Yeah, I think that's true. And part of that is with all those things that are going on with the person going through divorce or separation, um, with all those things that are going on, it's important that we allow them to gain a new skill set and understand that they probably that's a new experience for them,
Yes,
dealing with a conflicted party on important issues without shifting into anger mode.
yes. But it is what's best for your children. And so let's all learn to love our children more than we hate our ex.
Absolutely. That's critical.
Okay, well, we are out of time. It's hard to believe it goes by so fast. At least for me, it does. But thank you, George, for joining me in this again. And we'll be back next week. This is Dr. Marlene and George, and you've been watching The High Road on the Dr. Marlene YouTube channel. We'll see you next week.
Tune in to The High Road with host Dr. Marlene and gain insight into how to rise above tough circumstances and learn the skills that will help you take the high road in your life, no matter what challenges might come your way, on the next episode of The High Road.